Entrepreneur Network. If your business was sued today, what could they actually take from you? That's the question we're going to explore. And for many business owners, the answer is zero, nothing. But in fact, all or most of their personal assets as well as business assets are exposed. We're going to get into it. We're going to talk about how that actually happens. Well, the limited liability company. Most business owners default to the limited liability company upon formation of their business because it's easy to maintain. It's less formal than the corporation. You don't have to have annual meetings or keep minutes of those meetings. Now, let's talk about the purpose and scope of the limited liability company because most business owners, entrepreneurs, build their businesses backwards. And this is done by immediately moving to form the LLC or the corporation, next to secure an EIN number, and then open a bank account and start transacting business. That's the manner in which most entrepreneurs form and operate the business. But there's a deeper question. Where should the assets be placed? Valuable business assets. What should own those valuable business assets? We're going to talk about it because there is a built forward framework that the business owners are skipping over until such time that the pressure event, particularly litigation or lawsuits, show up. Now, the purpose of the LLC. Many entrepreneurs think that when you form the LLC, all of your personal assets as well as business assets are protected inside of that limited liability company. But that's not how it works. The limited liability company has a singular purpose, and the purpose is to separate your personal assets from any business liability. I'm going to state that again because there's a lot of misconception about it. The purpose of the limited liability company is to separate your personal assets from any potential liability. Now, as it relates to limited liability protection, it works the same way for the corporation as it does for the LLC. There is no distinction between corporation and limited liability company as it relates to limited liability protection. That's a big myth. Right? So you see it, I see it all the time on social media, people talking about form the corporation. It gives you a greater and better protection than the LLC. In fact, no such thing. Limited liability company has the same meaning. Now, the question we're delving into today is if your business was sued, what could they actually take from you today? And again, most business owners immediately think that because they have formed the LLC and they have the paperwork that goes along with that, the articles of organization, they're automatically protected as long as they file their annual reports timely and pay the annual fee. Well, the limited liability company formation and that paperwork only provides a container. That's what it provides. And the container is the place from which the business operates. That's what it is. Whether or not the limited liability protection is going to exist is to be determined. It's conditional. non-existent at the time of formation. It's conditioned upon how the business is actually operating, how the business owner moves money, how whether or not the business owner acts as personal guarantor for business activities, whether the business is properly capitalized. All of those things are going to be interpreted, those transactions that happen from the commencement of business. Those transactions are going to be picked up. In fact, they're sending out signals each time the business owner engages in a transaction, signing a lease, signing a contract, paying expenses, withdrawing money from the business. How do those things take place? Does the business owner sign on behalf of the business, or does the business owner, in fact, sign in their personal capacity without stating that they're actually acting on behalf of the business? All of those things send out a signal each time a transaction is entered into. Does the business owner act as a guarantor on behalf of the business? Those things go out. And when a pressure event arrives, institutions pick up those signals and interpret them to determine whether or not the business is separate from the owner or whether the business is actually dependent upon the owner, personal. That's what all institutions are going to be looking at some point in the future. They're going to be reading that historical data. And when I'm talking about, when I mention institutions, I'm talking about banks, courts. The court is the elephant in the room. It's the one that the entrepreneur always has in the back of their mind, that that's the place where harm can come from. But in fact, it's not only banks and courts, but insurance underwriters. When the business owner files an application for insurance coverage for the business as well as the business assets, the real estate underwriter, the investor, when they're performing their due diligence, regulators like auditors, the IRS. Now, while all of those institutions have their own way of looking at things and their own rules, they all share one very important thing in common, and that is that they're trying to determine whether or not the business is actually independent of the owner, whether the business operates independently of the owner or whether the business is dependent upon the owner. And these signals are going out constantly with each and every transaction that the business enters into, many times unbeknownst to the owner. They don't know that these signals are going to be picked up later. And the signals, in fact, are your historical data, your contracts that you signed, invoices, emails, communications with clients, vendors, employees. All of those things are going to be used to interpret whether the business, in fact, is independent. Now, we're operating, and when you form, for the informed entrepreneurs who know that from the beginning, the purpose behind forming either the LLC or the corporation is to create that separation to protect those personal assets. That's the purpose. The LLC has a singular purpose. It is only to protect business assets. But many entrepreneurs never ask the question about what is going to protect those business assets, the valuable business assets. Those are things like your real estate, your contracts, accounts receivables, intellectual property, the brand, the trademarks, all of those things. What protects those assets? Most entrepreneurs, when we default to the LLC and operate with that single LLC, that's it. Everything we own is contained within that single LLC. The business assets as well as the operating risk. If anything bad is going to happen, that's where it occurs, inside of the operating company. And when you form the single entity and only operate with that single entity and all of the valuable business assets are there, those assets have no protection because the LLC, again, has a singular purpose. It does not create any shield or protection between those valuable business assets and the operating risk. The purpose of the LLC is to provide a shield between the personal assets and the business liability, the business risk. It does nothing for those valuable business assets. So, in the event that the business activity causes harm or injury, and a claim is filed, and that claim results in a judgment being rendered against the business, then those business assets become immediately reachable. There is no shield, there is no protection. And so those assets can be seized and sold in order to satisfy the judgment. That's what I call the single entity trap that most entrepreneurs fall into when we form that LLC and think that everything across the board is protected. Now, here is the built backwards part. Most businesses are built backwards because entrepreneurs default to the common misunderstanding that all you have to do is form an entity, LLC, get an EIN number, get a bank account, and then start operating. That's a task list. That's not asset protection because you never gave any thought as to where those valuable business assets should be located. So when we ask the question, if your business is sued today, what could they actually take from you? If you're operating with a single entity, then all of your valuable business assets are at play. Real estate investors having multiple properties titled in the name of that single LLC, or maybe even worse, operating and leasing those valuable real estate properties in your personal names, using personal property in the LLC. Well, there's certainly no protection there. And in fact, the conversation or the classification will be almost immediate because if you're using properties titled in your personal name inside of your business in your LLC, that's exposure. That's personal. It's got personal written all over it. So the single entity trap is that those valuable business assets titled in the name of the LLC have no exposure. There's no shield. There is no barrier. Now, what else is exposed? Remember, the LLC has a singular purpose to shield the personal assets. But formation of that LLC receipt of the paperwork does not provide protection in and of itself. So those transactions that are sending out signals, those signals are going to be interpreted later to determine whether, in fact, the business owner operates the business separately from their personal life. Those signals are going to be picked up to determine whether or not the business owner is actually separate from the LLC. And if those signals return a classification that the business is not separate from the owner, then not only are the valuable business assets exposed, but the personal assets are going to be exposed as well. And if you're not totally familiar with how the LLC works or what the purpose of the LLC is, again, it is to create the separation between personal and assets and business liabilities. And I repeat that because many business owners think that the purpose behind forming the LLC is simply to go into business. It's deeper than that. There is a structural and legal meaning for forming the LLC, and that is to create that shield to protect the personal assets. Because we're going into business, the law affords you the opportunity to safeguard what you own personally. That's what it's for. We safeguard what's owned personally. Now, there is no rule in any state, statute, anything that says that before business services or products can be sold, that either an LLC or corporation has to be formed. You don't have to form either. And many business operators begin providing services and selling goods without forming either. Those are called sole proprietorships. You can immediately go out and start providing goods and services. But the problem with that is that if that activity causes harm or injury, then there is no protection. Those personal assets are immediately available to be seized and or sold to satisfy the judgment. The sole proprietor has to either write the check to satisfy the judgment, or those assets can be used to satisfy that judgment. So that's why we form the LLC or the corporation. It's not simply to say, I formed the business, I'm in business. There is a legal significance to doing that. It provides a safeguard for your personal assets. Now, imagine this. Here's how many entrepreneurs operate. Imagine for a moment that your entire financial life is plugged into a single power strip. Your home, your bank accounts, if you're operating a business on the side now and maybe you're still employed, your salary is plugged into that power strip, retirement accounts. And then you form the LLC, and the LLC gets plugged into the same power strip. That's contracts, accounts receivables, real estate, intellectual property, the brand, business equipment, everything in your financial life plugged into that one power strip. That's how many entrepreneurs operate. There is no separation there. Nothing is unplugged. And so when there is a power surge, maybe in the form of a lawsuit, a partnership conflict, employee dispute, then everything is exposed. And many business owners are blindsided at that point. They're saying things like, well, that has nothing to do with this, and at least this is protected. But that's not the case, because there was, in fact, no separation. I've represented many business owners over the years who believed that they were actually protected when an event occurred because they had either an LLC or a corporation, but they never actually separated from the entity. So when the event occurred, everything was at risk. But prior to the event, everything felt fine. And the reason for that is because business structure is never tested during calm periods. When everything is fine, when everything is calm, there is no testing of your structure. Business structure is only tested during those pressure events, when the lawsuit is filed, when the partnership conflict occurs, when someone wants to exit from the business, when we're trying to determine what the valuation is of that interest. Those are pressure events. And that's when those signals that had been sent out, those signals created historical data, because now all of those institutions, depending upon what pressure event it is, whether it's litigation, we're responding at court, whether it's a bank loan and you're going through the underwriting process there, whether it's insurance underwriting, real estate underwriting, due diligence, that's when those signals get interpreted. And it's all historical data. All of those institutions, they live in the past. There is rarely any opportunity provided for clarification. Means you can't come and sit there now and explain away what was going on. And that's how many business owners get tripped up. It's already occurred. The history is already there. The business has been classified a long time ago, but you just didn't realize that it was happening with those transactions. Those signals that were being sent out, the activity, it just feels like the business owner, the entrepreneur, was doing what he or she needed to do to make the business go. And in reality, you were. But in fact, those signals were providing a roadmap to determine whether or not the business operates independently of you, or whether in fact the business is dependent upon you. And the first thing that many business owners default to in the conversation is that, well, my paperwork is in order. How could it be? I'm not particularly disturbed by it early on. My paperwork is in order. But paperwork is not protection. It doesn't provide any protection. In fact, the paperwork can become irrelevant over time. And when the institution is going through the process of classifying whether the business is separate from the owner or personal, the institutions, in many instances, place the paperwork aside. The paperwork becomes irrelevant. And one of the reasons that the main reason that the paperwork becomes irrelevant is because the business activity, the business behavior has drifted away from what's inside those documents. And when I'm speaking of documents, I'm really speaking of the operating agreement. We're talking about the LLC, or the bylaws. We're talking about the corporation, the shareholder agreement on the corporation, regulating the relationship between the owners, the shareholders. Those documents are internal documents on how the business operates. But in the beginning, when you receive those documents, they're really just representing intent. They represent how the business intends to function, how the business intends to operate. But as the business begins to operate, once that container is in place and the business begins conducting transactions and entering into transactions, sometimes those transactions are not in alignment with the intent, with what's stated in those documents. Now, once or twice, the business owner steps away and acts in a manner inconsistent with what's in the document. For instance, it's never the intention or rarely the intention and stated in the operating agreement that the business is going to operate such that the business owner is just continuously throughout the duration going to inject personal cash into the business to operate it. But it happens. Once or twice, it may be construed as just noise or coincidence. But if that behavior begins to show patterns that this is how the business operates, and those patterns repeat themselves over and over again, then despite what's stated in the operating agreement, the real structural identity of the business is there. It's presented right there. The business is dependent upon the owner. The business does not generate sufficient cash flow on its own to operate independently. That signal is saying that the business is dependent and therefore it's not separate. It's personal. And so when the classification is being made, whether you're at court and the court is asking who controls, who owns, how does the money move, who absorbs the risk, who stands to benefit from the business activity, then they're not looking at the paperwork and the owner is amazed, blindsided by the fact that nobody is sitting there looking at the paperwork. The institutions begin to look at behavior. And I say this all the time to business owners. Business structure is not legal. It's not a legal issue. Okay? Business structure is a behavioral question because once the business owner receives the container, everything is going to be determined by the activity, business behavior of the entrepreneur, how you move. That's what's going to determine whether or not the business is separate from the owner or personal. Now, the legal part comes in when a conflict arises. There's no legal part at the bank. Neither are there any legal considerations in the insurance underwriting, real estate underwriting, investor due diligence. None of those institutions are sitting there asking legal questions. They're all behavioral questions. The investor wants to know who controls the business. Is there continuity established? What happens if the owner has to walk away, step away from the business? Does the business continue to operate on its own? Or is everything frozen at that point? Because everything depends upon the owner. Is the owner the only one with the institutional knowledge about the business? How do vendors view the business? Do vendors think that they're actually transacting business with the entity, with the business, the LLC? Or are they transacting business with the owner? Is everything based upon the relationship with the owner? Those are all questions to get to the bottom of whether or not the business operates separately or personally. Now, the question is, if your business is sued, what can they actually take from you? Well, we talked about the single entity trap. That's where the business owner, entrepreneur defaults to forming the LLC, getting an EIN, opening a bank account, placing all of the business valuable assets inside that LLC. We've already established that there is no protection there. The LLC was not built to protect valuable business assets. Its only purpose is to separate and protect personal assets from business liability. So those business assets are exposed from the beginning. Now, if the business owner, entrepreneur also goes back and forth as it relates to movement of money, using business funds to pay personal expenses, and vice versa, injecting personal cash into the business without proper documentation like capital contribution agreements or loan agreements to reflect that these funds are actually being loaned to the business or injected into the business as part of the equity, then those signals are going to be picked up as personal. And not only are the business assets exposed, but the personal assets are exposed as well. So the answer to the question for many entrepreneurs, if your business is sued today, what can they actually take from you? The answer is everything. The extent of what will be taken is a function and dependent primarily upon the amount of the judgment. If it's a small judgment, then they'll take whatever is necessary to satisfy that amount. But if it's a large judgment, if the judgment is substantial, then substantial assets are going to be at risk. And they may start out with the business assets. And if there are sufficient business assets there to satisfy the judgment, then it'll stop right there. But if there are not sufficient, or if there's not sufficient business assets to satisfy that judgment, now it moves over to the personal side. So at the end of the litigation, since the elephant in the room is the courthouse, right? And that's the one that business owners think about most, that we stay up at night thinking about. Then, once the lawsuit has been completed and liability has been determined to exist at the business, business is responsible for the harm that occurred. Now, the analysis shifts into whether or not the business owner's personal assets are going to be at risk, whether or not the corporate veil is going to be pierced. And the consideration in determining whether or not the corporate veil will be maintained or will be pierced is a function of the court reading those signals, that historical data that's sent out there in the form of contracts, communications, acts of guarantee, all of those things. Questioning again, who owns, who stands to benefit, where did authority lie, how did the money move? all of those things. And if most of those answers lead back to the owner, to the entrepreneur, then it's going to be personal. And now those personal assets can be seized and sold in order to satisfy the remainder of whatever has not been satisfied to date on the judgment. And in many instances, the analysis goes straight to the personal assets because there's not sufficient business assets there. So if you're operating a business and there's real estate assets, and intellectual property, and cash reserves, and all of those things, and you're operating with the single LLC, you're exposed, bar none. That's just the reality of it. Many entrepreneurs have been misled, miseducated about the purpose of the LLC. It doesn't protect business assets. It doesn't shield your value from your risk. And value and risk should always be separate. Value and risk should be separated. The proper built forward structure is the use of separation of ownership from control, and ownership and control is also separated from the operating risk. So what does ownership look like? That's the trust, establishment of the trust. It provides for business continuity. It provides and determines who the beneficial interest holder is. Who's going to benefit from all the activity? Where does it go? Who does it belong to? That's what the trust establishes. That's its function. But it also serves to keep the owner's name off of the business and off of the business assets and out of the line of fire from the operating risk. Many business owners, if we went to the Secretary of State's website right now, it's a very easy determination as to who owns, who controls, who stands to benefit. It's right there, public facing. The entrepreneur's name is there in many instances as the sole member of the LLC or multiple members if there's more than one. It's right there. Registered agent of the LLC. It's not a far-fetched conclusion to arrive at. If a person is the member and the registered agent, they're probably the beneficial interest holder. Your name is there as the interested or the responsible party at the EIN. At the bank, you're signed there in your individual capacity as the owner of the account. If you're receiving online payments from some of the payment gateways, Stripe and PayPal and all of those type of commercial entities, the name is there in a personal capacity. So it's not a far-fetched conclusion to arrive at that you personally own and you're acting in your personal capacity. Well, providing the structure, the layered structure, you eliminate all of that. You eliminate your name from the public-facing entities. Ownership is at the trust level. Those valuable business assets that are immediately exposed if you operate the single LLC, those assets become shielded at the control level. That's the holding company. And the holding company is an enigma or a mystery to many entrepreneurs. We don't know what its purpose is. How does it work? Well, the purpose of the holding company is to provide that shield, that protection, to separate value from risk. So the value is owned and placed at the holding company level right above the risk. So if the business activity causes harm or injury, the holding company, the control and asset layer had absolutely nothing to do with it. Therefore, those assets are protected, they're shielded, they're safe. The holding company, it does no business. It doesn't have customers, it doesn't sign contracts, it doesn't engage in any activity. The only relationship activity that occurs with the holding company occurs between the holding company and the operating company. The holding company acts as a support system, if you will, for the operating company. It holds the assets or owns the assets from which the operating company uses to do business. So everything is shielded. There is a layer, a shield between ownership and assets, control. There is another layer between assets and risk. That's how the business should be formed. That's protection. Now, it's also important that the entrepreneur understand how these entities relate to each other. Because if you find yourself embattled or engaged in litigation, the question is going to always come down to, is the structure real or is it just a sham? And many veils are pierced because the entrepreneurs, even though there's paperwork available, the business behavior does not match the paperwork. Remember what I said earlier, that there is a common misconception among entrepreneurs that paperwork and formation provides protection, but it doesn't. It's conditional. Protection is conditional upon business behavior. And that is because the behavior is going to leave patterns. And over time, those patterns become repetitive. And repetitive patterns are later analyzed, classified by the institutions, banks, courts, underwriters, investors, regulators, to determine whether, in fact, your business operates independently of you or whether the business is dependent upon you. And I know, look, every time we have these conversations, for many business owners, it gets uncomfortable because to come into the knowledge or understanding that all of those valuable business assets, and many entrepreneurs are out there operating with millions of dollars in business assets, totally exposed and unaware that, in fact, they're exposed. And the statement sometimes is like, well, I mean, I'm not exposed. The business is successful. Revenue grows year over year. We're getting new contracts. We're hiring new employees, all of these things. But success hides or can hide exposure. Again, remember this, business structure is not tested during calm periods. If you're not applying for credit, or if you're not going through an audit, or if there's no litigation, then no one's going, unless you're astute enough to keep an eye on your structure, no one's going to send you a notice saying that something's wrong with your structure. Check your structure. It doesn't happen. It's only tested during one of those events. That's when it's going to be brought to your attention. And again, the business can survive the denial of a credit application or the bank request that the owner has to act as a guarantor in order to get the loan. The business survives there. The business will probably survive if an investor, during the course of their due diligence, decides that maybe the business is not separate, it's dependent upon the owner, and walks away. That activity does not take anything away from the business. It does not place the business in any kind of immediate peril. But the lawsuit, that one, that can, in some instances, many instances, be fatal to the business. So again, I understand that these conversations can be uncomfortable. If you're noticing your business behavior, that you're sending out any of those signals, that your assets are exposed. But if you're not involved in litigation or any kind of pressure event right now, consider it an awareness, an awakening, and the perfect opportunity to fix the structure in your business. And I get this question all the time. Do I have to dissolve anything? Do I have to start over in order to structure properly? And the answer is no. You don't have to dissolve. You don't have to sacrifice identification numbers. Many business owners, particularly those doing business with the government, those employer identification numbers are important because they're assigned and attached to contracts. None of those things get compromised. The business owner who wants to take responsibility for his or her own structural literacy, understanding the business as well as legal environment in which they operate. I call that person the pro sepreneur. You may be familiar, may have heard the phrase pro se before, generally used within the context of someone who represents his or herself in court. That's not what we're talking about. The phrase really means for oneself. That's what pro se means, for oneself. We know who the entrepreneur is. The business owner works for his or herself. So the pro sepreneur is that business owner, that entrepreneur who chooses to take responsibility for his or her own structural literacy. Look at where the misconception has already occurred. By outsourcing your business structure and thinking that it was actually set up to provide asset protection. But in fact, what really happened was that you just outsourced to someone to form an entity for you. And many of you do it for yourselves, but that's not business structure. That's formation. That's compliance. That simply means that you have engaged in the minimum requirements necessary to be recognized by the system, to receive your container for the future opportunity to secure limited liability protection. And that's to be determined on how you actually operate the business. How does the business behave? So the pro sepreneur is a person who understands how to move on a daily basis, who understands the relationship between the trust holding company and operating company, particularly the holding company and operating company, because that's where the veil has the potential of being pierced. That's where they're going to say that the relationship, albeit paperwork existing, is a sham. How are those assets being used? How are they titled? Is value being provided for the use? All of those things. The pro sepreneur knows the answer to those questions, and not only knows the answer to those questions, understands how to operate within the context of the existence of those relationships. And that's the service that I provide here at Free Law School, coaching business owners on how to structure the business properly. If you're not engaged in litigation right now, that pressure event, it's the perfect time. It's the next best time to structure your business properly. We've already passed the first opportunity. That was formation. But again, it's okay if there are no pressure events now. And here's why it's important. It's important because once the pressure event arrives, the business owner cannot readily move assets around. You can't just move assets once the lawsuits are filed, judgments are pending, or judgment rendered. Now things are frozen. You're stuck at a status quo until such time that that judgment is either satisfied or assets levied, seized, and sold in order to satisfy that judgment. But if you're structured prior to any of those things happening, then those assets are going to be protected, both personal as well as business, structured and behaving in accordance with the structure. That's important. So again, if you're operating and you see your operations within the context of what I've described to you, lapsing in and out between sending out personal signals versus independent signals, then I've created a tool for you to use to evaluate how you're actually operating the business. It's going to review ownership, control, assets, risk, as well as continuity. And when I say evaluate, look at how you're actually operating. What signals are you sending out? That tool is at the link in the description. It's complimentary. Use the tool to determine how you're operating. It's going to give you a score. It is going to tell you in each of those categories how you're operating, where your exposure is, and help to provide a roadmap on what needs to happen going forward in order to fix your structure. Now, restructuring doesn't erase history, but if you don't have any pressure events in the history, then it's okay. No problem. Because once you restructure, then if an event occurs, your classification is going to be determined based upon how you moved from the restructure point forward. And that's where that event is going to be forward. So if you're operating properly, if you're structured and operating, moving properly, then your assets are going to be protected. Because in fact, the real purpose behind layering is that when that judgment is rendered, if a claim occurs and the judgment is rendered and the owner understands how to operate and operates the business accordingly, the personal assets are going to be safe, the business assets are going to be safe, and the liability imposed on the operating company, but the operating company owns nothing. Worst case scenario is that that operating entity now has to be dissolved, but you still, the business still owner still has those valuable assets, personal and business. So you dissolve the business, form a new entity, and continue to operate, but under a different name. That's how it was designed to operate. That's how wealth and legacy is perpetuated. People don't lose assets, but structure is going to determine what survives. Again, if you'd like to use the tool to determine where your exposure is, whether you're exposed and how you operate your business, the link is in the description for the Structural Exposure Diagnostic. Send me a message on IG. Let me know what your experience is as it relates to business structure. What's most concerning to you as it relates to putting together the trust, holding company, or operating entity structure. And after you finish your structural diagnostic, download it because we don't keep it. So if you'd like to have a conversation with me afterwards, you can bring that structural, that PDF downloaded diagnostic, yours, to the meeting, to the call, and we can map out where your exposure is and actually what it's going to take to fix it. Thank you guys for joining this morning on the Prosapreneur Network, and we'll talk again.